Section 8 and 9 Children Act 1989 Child Arrangement Orders. Section 8 Children Act 1989 as amended by Section 12 Children and Families Act 2014 provides for the child arrangement orders and other orders with respect to children. Section 8 Subsection 1 provides: in this act, a prohibited steps order means an order that no step which could be taken by a parent in meeting his parental responsibility for a child, and which is of a kind specified in the order, shall be taken by any person without the consent of the court. A specific issue order means an order giving direction for the purpose of determining a specific question which has arisen or which may arise in connection with any aspect of parental responsibility for a child. Section 8, Subsection 2 provides: in this act, child arrangements order means an order regulating arrangements relating to any of the following: open brackets, close brackets A, with whom a child is to live, spend time or otherwise have contact, and open brackets, close brackets B, when a child is to live, spend time or otherwise have contact with any person. Section 8, Subsection 3 provides: for the purposes of this act, family proceedings means any proceedings, open brackets, close brackets A, under the inherent jurisdiction of the High Court in relation to children, and open brackets, close brackets B, under the enactments mentioned in subsection 4, but does not include proceedings on an application for leave under section 100 subsection 3. Section 8 subsection 4 provides: the enactments are open brackets, close brackets A, parts 1, 2 and 4 of this act, open brackets, close brackets B, the Matrimonial Causes Act 1973, open brackets, close brackets BA, Schedule 5 of the Civil Partnership Act 2004, open brackets, close brackets C, the Domestic Violence and Matrimonial Proceedings Act 1976, open brackets, close brackets D, the Adoption and Children Act 2002, open brackets, close brackets E, the Domestic Proceedings and Magistrates Courts Act 1978, open brackets, close brackets EA, Schedule 6 to the Civil Partnership Act 2004, open brackets, close brackets F, sections 1 and 9 of the Matrimonial Homes Act 1983, open brackets, close brackets G, Part 3 of the Matrimonial and Family Proceedings Act 1984, open brackets, close brackets H, the Family Law Act 1996, open brackets, close brackets I, sections 11 and 12 of the Crime and Disorder Act 1998. Section 9, Children Act 1989 as amended by Children and Families Act 2014 provides some restriction on making Section 8 orders, and they are as follows. Section 9, subsection 1 states: no court shall make any Section 8 order other than a child arrangements order to which subsection 6b applies, with respect to a child who is in the care of a local authority. Section 9, subsection 2 provides: no application may be made by a local authority for a child arrangements, and no court shall make such an order in favor of a local authority. Section 9 and subsection 3 provides: a person who is or was at any time within the last 6 months a local authority foster carer or foster a local authority foster parent of a child may not apply for leave to apply for a Section 8 order with respect to the child unless, open brackets, close brackets A, he has the consent of the local authority, open brackets, close brackets B, he is a relative of the child, or, open brackets, close brackets C, the child has lived with him for at least 1 year preceding the application. Section 9, subsection 4 was repealed by Section 113B of the 2002 Act. Section 9, subsection 5 provides, no court shall exercise its powers to make a specific issue order or prohibited steps order, open brackets, close brackets A, with a view to achieving a result which could be achieved by making a child arrangements, or, open brackets, close brackets B, in any way which is denied to the High Court by Section 100 subsection 2 in the exercise of its inherent jurisdiction with respect to children. Section 9 subsection 6 states, no court shall make a Section 8 order which will end after the child has reached the age of 16 unless it is satisfied that the circumstances of the case are exceptional. Section 9, subsection 6A provides, subsection 6 does not apply to a child arrangements order to which subsection 6B applies. Section 9, subsection 6B provides, this subsection applies to a child arrangements order if the arrangements regulated by the order relate only to either or both of the following, open brackets, close brackets A, with whom the child concerned is to live, and, open brackets, close brackets B, when the child is to live with any person. Section 9, subsection 7 provides, no court shall make any Section 8 order other than one varying or discharging such an order with respect to a child who has reached the age of 16 unless it is satisfied that the circumstances of the case are exceptional.